Hi, I'm Phil Ashey from the American Anglican Council, come to you on behalf of the ACNA Governance Task Force with our first draft of Constitution and Canonical Amendments for Provincial Council 2022. You'll be glad to know that this is going to be relatively brief and very few amendments that we're going to offer, none to the Constitution, all to canons. And I'm going to start with just some really almost grammatical changes to two of our canons. One is in Title IV, Canon 2, regarding charges. And if you go down to Section 9, you'll see that we have changed this now to read disobedience to or willful contravention of the canons of this church or the constitution or canons of the diocese in which such clergy holds office. And we propose this to clarify what is meant by disobedience. Charges could be brought for disobedience to a godly admonition under Title 4, Canon 2, Section 1, Sub 12, to the Constitution, which is Sub 8, or to the canons of the church or the clergy person's diocese. And that's what we're doing in clarifying the language in this canon. The second grammatical correction is in Title IV, Canon 10, of notification of disciplinary action taken. And that is a very simple hanging of in the very last phrase, that the Archbishop shall promptly give notice to all bishops with jurisdiction of and record the amendment. Well, the of is really unnecessary, so we're just striking the of, but otherwise that section remains exactly the same. The third change has to do with a new canon that we've added to Title III, Canon 8 of bishops, and this is a new Section 9 concerning voluntary resignation by a bishop from the ordained ministry of this church. And it's been pointed out to us that we have a provision for the resignation of presbyters and of deacons, but we don't have that for the resignation of a bishop. This may be the subject of an upcoming Archbishop's Customary, but in the absence of an Archbishop's Customary, we ask you to take a look at this proposed Section 9, which follows the same requirements that we have for presbyters and deacons, namely that any bishop in good standing may resign from the ordained ministry of this church by sending a resignation in writing to the Archbishop, and the Archbishop shall record the declaration and request so made, and shall determine that the bishop is not under discipline, as defined in Title IV of these canons, and that the resignation is not occasioned by misconduct or irregularity, but is voluntary and for causes which do not affect the moral character of the bishop. So in other words, bishop, like a presbyter or deacon, can't avoid church discipline by just going ahead and resigning. Upon making the determination, the Archbishop defers formal action upon the declaration for 2 months and lays the matter before the College of Bishops for advice and consent. That's the same, essentially, counterpart to what the Standing Committee would do in a diocese for the voluntary resignation of a presbyter or a deacon. With its advice and consent, the Archbishop may pronounce that such resignation is accepted and that the bishop is released from the obligations of the ministerial office, that he relinquishes the right to exercise in this church the gifts and spiritual authority of a shepherd of the flock. And then it goes on to say, just as we say for resignations voluntary of presbyters and deacons, that the resignation was for causes which do not affect the bishop's moral character, and shall, if requested, give a certificate not only to the bishop so removed from the ministry, but that where that resignation has been accepted, the bishop may also request that the Archbishop write a commendatory letter to another Christian denomination or jurisdiction. Now, if the resignation or renunciation of the ordained ministry of the bishop involves a question of misconduct or irregularity, see, that goes to Title IV, and sections, actually Canon 7 and 4. Canon 4.7 and Canon 4.4. Now, if a bishop voluntarily resigns from ordained ministry and is not under the discipline of any ecclesial body, he may petition the archbishop to restore the right to exercise in this church the gifts and spiritual authority as a bishop conferred in ordination. But in the same way that for presbyters and deacons, such restoration would have to take place in the same diocese and under the same people who granted the resignation in the first place, so also for a bishop, the terms and conditions of restoration shall be entirely within the discretion of the archbishop with the advice of the standing committee of the bishop's previous diocese, which is important because they will have been involved in this process as well, and with the advice and consent of the College of Bishops. Our next canonical change is again in Title IV. Most of the changes we're going to be talking about are actually in Title IV and having to do with church discipline. And this is Canon 2 of charges against and godly admonitions to bishops, presbyters, or deacons. And what we've added here is a very important phrase, and that is that a temporary suspension from the exercise of ministry requires an inhibition pursuant to Canon 9 of Title IV. And there's a reason for that. During Provincial Council 2021, it was noted that godly admonitions have often included a de facto inhibition. And there's no check on an admonition, whereas for an inhibition, there's a right of appeal to the standing committee and so forth. So this is an attempt to clarify that and make clear that you cannot suspend someone from ministry, whether they're a deacon, a presbyter, or a bishop, by a godly admonition alone. There has to be an inhibition. And that inhibition is subject to Title IV, Canon 9, and all of the processes outlined in that. Now, concerning a godly admonition, there are a couple of other things that we wanted to point out about that as well. And that is, in the case of an admonition to a bishop, this is such a serious issue that we've asked that the archbishop must first, before he actually even does the admonition, obtain the written consent of 3 of the 5 senior active diocesan members of the College of Bishops by date not of consecration but of admission. And that's because we've had an influx of bishops from other denominations, so we want to make sure that we have the seniority of bishops and their wisdom in whether or not to approve an admonition by the archbishop. This provides a great check and balance. And so we've changed the language from date of consecration to date of admission in both of those paragraphs. The next set of canonical changes are under Title IV, Canon 9, concerning inhibitions. And there is a lot of discussion at Provincial Council 2021 about what needs to be in place before a bishop can be inhibited. And so while there was some disagreement about the need for a presentment, we're looking at sections 2, 3, and 4 and amending them to clarify that an inhibition of a bishop is lifted when charges arising from a presentment are dropped. And these amendments also explicitly afford one having the authority to inhibit the power to lift the inhibition with notice to the body that consented to the original inhibition or extension the standing committee, in the case of a presbyter or a deacon, or a panel of senior bishops by date of admission for a bishop. In the event of an inhibition of a bishop, notice to the standing committee or its equivalent of the bishop's diocese who's being inhibited shall be given within 24 hours. And again, that was something that we talked about at length in Provincial Council 2021. Inhibition of a bishop is going to be subject to a majority vote rather than a unanimous vote. In response to very strong urging that the review of any inhibition of a bishop be subject to a majority vote rather than a unanimous vote of a new panel, we submit the amendments here for consideration and hope that this more generous appeal might help prevent, for example, what happened to Bishop Love in the Episcopal Church, who was inhibited for months and months with no presentment. Now, when we presented these amendments to the College of Bishops in January, they affirmed the desire not to have our bishops repeat the same problem that Bishop Love experienced about being inhibited or suspended or removed from ministry without any facts, without any kind of offer of proof. And so there was a very good discussion in the college about whether the panel of 5 senior active diocesan members by date of admission in the college needed to be unanimous or, as one bishop argued very strongly, simply a supermajority. And so we're going with the supermajority language. So let's just walk through Title 4, Canon 9, Section 3 concerning inhibition of a bishop. So Paragraph 1 says the Archbishop may temporarily inhibit a bishop under this canon. Prior to such temporary inhibition, the Archbishop must first, that's the new language, obtain the written consent of 4 of the 5 senior active diocesan members of the College of Bishops by date of admission. The changes in paragraph 2, with the written consent of 4 of the 5 senior active diocesan members of the College of Bishops by date of admission. And then it goes on to say that any inhibition of a bishop may be extended until the Archbishop lifts the inhibition with notice to the standing committee of the diocese of the bishop inhibited and the panel of bishops which authorized an extension of the inhibition. Any charges arising from a presentment are dropped, or action is taken by a court, or there's a voluntary submission to discipline. Now, paragraph 3 goes on to say, upon application by a bishop who's been inhibited under this canon, and upon a showing of good cause, 4 of the 5 senior active diocesan members of the college, by date of admission, exclusive of the bishop subject to the inhibition, any bishop involved in the original inhibition, and any bishop who may recuse himself may by majority vote, so that means 3 out of 5, majority vote, modify or revoke the inhibition in writing. So that's a generous right of appeal to a bishop who's being inhibited, and such decision shall be rendered within 30 days. Now, we do exactly the same process in Title 4, Canon 9, Section 4, concerning the inhibition of an archbishop, but I just ask you to take a look at the language in that canon. I won't repeat all of it. The difference is that the dean of the province must first obtain the written consent of 4 of the 5 active diocesan members of the college by date of admission. Again, notice to the Archbishop's standing committee of his diocese. The dean of the province may lift the inhibition with notice to the standing committee, and any charges arising from a presentment, when those are dropped, action taken by a court or the accused voluntarily submits to the discipline of the church. That would be the archbishop. And the same process that by majority vote of 4 of the 5 senior bishops, by date of admission, by majority vote, they may modify or revoke the inhibition in writing. Those are our amendments to the whole process of inhibition. And they speak to the need, again, that there be an inhibition for any suspension, an inhibition in writing for any suspension in whole and in part of anyone's ministry in holy orders. Just a point of clarification, too, that the necessary threshold for inhibiting someone under Title IV, Canon 9 is reason to believe that the person in holy orders, deacon, presbyter, or bishop may have committed offense under Title IV, Canon 2, or Canon 1, the charges, and that it's in the best interest of the church. That's a threshold that actually can be reached well before a canonical investigation is done. Now, the final set of amendments are to Title IV, Canon 5, sections 2.2 and 4.2. And these address our need for the Archbishop to fill vacancies on the provincial tribunal and the court for a trial of a bishop in the event that a list of alternatives, or actually of alternates, is exhausted. And the reason for that is that, yes, we elect people to the courts, we elect alternates, but it's possible by virtue of multiple cases being tried or the possibility of recusal that we may run out of people to fill those positions. So we've added, with regards to the court for the trial of a bishop, that in the event the list of alternates is exhausted for an order, that is a bishop, clergy, lay, the Archbishop shall fill those vacancies in consultation with the executive committee, which is the same thing as the standing committee for the province, until the provincial council meets to elect members of the courts or alternates. And then same thing, same language in the provincial tribunal. In the event of a vacancy, the Archbishop shall fill those vacancies in consultation with the executive committee until the provincial council meets to elect members of the court or alternates. Those are the canonical changes. There's actually not many of them, even though we've taken some time to go through them. I want you to know that the Governance Task Force is busy looking at a number of issues that have arisen, and we will be working on those not in time to address before Provincial Council 2022, but we will give a report to you as soon as we have addressed some of those issues. So here's the timeline. We're publishing this first draft today, Tuesday, March 1. We're giving you 30 days. That's everybody in the province has 30 days to send to me, and here's my email, which will appear on your screen, pashy@americananglican.org. Any comments you have on any of these changes. We're going to have working groups in the Governance Task Force that I will forward those to, and they will get right back to you. On March 31, the time for offering comments will close. So you've got 30 days. And the Governance Task Force working groups will go ahead and we'll make whatever changes we deem appropriate in light of the comments we've received. On April 18, which is the Monday right after Easter, through May 9, we'll send a second draft out, and this will go to members of our Anglican Legal Society, chancellors, and every deputy that's been identified as going from every diocese and every ministry partner to Provincial Council in 2022. And they will have 21 days, 3 weeks until May 30th to get that into us. And then what we will do is we will send out the final draft to all bishops, clergy, and lay deputies on May 31st. Okay? So, and then Provincial Council will be June 14 through 16. So that's our timeline. If it changes, we'll make a note of that. But we do covet your prayers and your participation in this important process. God bless you, and we look forward to hearing from you.